In this session, we will see about the government contracts. Government contracts are dealt with in Article 299. Article 299, Clause 1 says the agreement should be made by President or Governor. If it is in the case of Government of India, it's President. If it is a state, Governor. You should be in exercise of their executive power. The person should have the proper direction to execute the agreement. For example, if electricity board in a government department is signing an agreement, it should say that by the order of the President, I am signing this. The agreement will be with the person and the President. As if the governor is signing, the other person is signing the agreement on behalf of the governor or on behalf of the president. So, three conditions. Agreement should be in the name of the president or governor. It should be by exercise of their executive power. The person signing should have the direction to sign. Three things. From this we can see that the agreement should be in writing. Then only you can have all the condition. Even though it is not mentioned, it should be in writing. These are the conditions to safeguard the public from the officials of the government and the government from the third party cheating the government. So restrictions are there to make it as in writing, and it should be mentioned like this. Even if it is not there, if contract is there, you cannot presume something as implied. It should be in writing. There is no provision for implied contract. In one case, Chaudhary versus State of UP, State of Madhya Pradesh. In this case, there was a bidding. Before bidding, the person signed a letter that he will abide by the terms of the bidding. But later he told that I will not abide by this condition because there is no agreement. Court held there is no agreement because the agreement is not made in the name of the governor or the president. So there is no agreement. There is no provision for implied agreement. This is a rigid rule. It should be in writing. It should be mentioned in the name of the president or secretary in execution of their executory power. And it should be executed by the person who is authorized. The main condition is it should be in writing. In Union of India versus Ralya Ram, it was for a purchase of cigarette. There was exchange of letters. There was an arbitration agreement. Subsequently, they contested that this is not an agreement because it is not in writing. But even then the court held it is a corresponding between the two, government and the other party. From this we infer that there is a agreement. Then the person signing should have the authority. The authority may be conferred upon him by an order, or it may be published in a gazette notification, or the order may be given to him by way of a rule. Rules framed under an act. There must be an authority. It should be expressed in the name of the president or governor. If it is not expressed, it is not a valid contract. In Bigraj Jaipura versus Union of India, food grains were supplied to the railway authorities. The executive engineer has placed the order, but it was not expressed in the name of the president. Goods were supplied, but court held there is no proper agreement. If there is no mention about the governor or the president, it is not an agreement. An agreement is void. An agreement which does not satisfy the condition mentioned in Article 299 Clause 1 is not valid. It is a void. Since it is a void agreement, it cannot be ratified. void agreement cannot be ratified. But the courts give some relaxations on this matter. If the government has to get some benefits, then they relax it. State of Bihar versus Karamchand Thapar case. Unauthorized persons entered into a contract, but the government has to get some benefit. Even though authority is not there, government has to receive the benefit, so the courts recognize the agreement, recognize the contract, because some benefit has to come to the government. There is no estoppel, there is no implied, no ratification in government contracts. It is void, so no ratification. This government contract is not applicable for the service person. A person joining the government services are governed by the service rules. So this rule is not applicable to the person who are joining the government services. Another one, this rule is not applicable where it is a statutory authority. For example, if a state government is giving a permit to a person to sell Indian-made foreign liquors, then it need not say by the order of the governor. He can straight away give a permit, because the authority is derived from the statute. Statutory authority is there means he can straight away say that what 299 says is about entering a contract. For statutory authorities, you can straight away say that this is the position, you can get this, you can order that this can be done. In the next session, we will see about the liabilities under the contract, government contracts.